potential strategy and mitigation and all of that kind of stuff if we're gonna go. And so I don't disagree that the state needs to make that decision. Right, so you are Larry Fitzgerald Williams?
Yep.
And Mr. Williams is charged in cause number 25 DCCR 0985 with capital murder. And Mr. Cash, it looks like filed yesterday, which is, we're here just on an announcement, I believe, but filed yesterday, a motion to compel the state to declare their intent to seek the death penalty or not. And Mr. Smith what is the state's position? Do y'all have one yet? I think that's obviously very important at this.
Yes.
This is from a murder from June of 2025. So if it's not been declared, I think it's time. I would agree.
Well, as far as I understand the law, Judge, the punishment for capital is the death penalty unless the state waives that. We've not waived it yet.
I understand what the law is. I also understand that the case needs to be set up a whole lot different from the court's perspective. If we're going to set this for trial, then we need 6 or 7 weeks. From Mr. Cashin's perspective, he's got a very different potential strategy and mitigation and all of that kind of stuff if we're going to go. And so I don't disagree that the state needs to make that decision. It's time for all of us to be setting it for trial or working something out. And if I'm going to hang on, if I'm going to set it for trial, I need to know what I'm setting it for trial for. So here's what I'm going to do. I'm going to reset the case, one reset for you to meet with whoever you need to meet with. I am going to order that there isn't an answer because we will be either setting it for trial or it'll be the end of the announcements. It's either going to be worked out as some type of plea or we're going to be setting it for trial at that next court date. And I need to be able to know what I'm setting it for. So get with whoever you need to get with. Let's get an answer between now and then so that we all know how to go forward. Since we're at that point, we'll be 10 months out. So it's time to figure out what to get it set for. So I'll reset it and we'll get that at that next court date. All right. You can go back with the bailiff.
Look at the camera myself.
Good morning. Are you Carlos Rodriguez?
Yes.
And just for the record, Mr. Salinas, you're going to be able to translate for Mr. Rodriguez today.
Yes, sir.
All right. And Mr. Rodriguez is charged in 24 DCCR 1584 and 1585 with indecency with a child by sexual contact. And what is the announcement?
Ready, Your Honor. I guess last time we were here, we had to deal with the inspection videos. So it looks like that was, I'll bet after your order was signed, both me and the state were able to get those videos and an investigative report.
Good.
There. So, and I believe state also filed motions for you to do an in-camera inspection of some CPS records regarding the children.
That's correct, Your Honor. There could be exculpatory information there, and so I do like to request those records if necessary.
I signed that order just yesterday.
Okay. Yeah.
So that takes a little bit to get those records back.
Understood. And I was unopposed anyway to that, so that's fine.
All right, so I guess what we need to do is reset it to get those records back. And then as soon as that happens, and typically what happens is they send 3 copies. They send an unredacted version to me, a redacted version to both of you. So you'll be able to go through it yourself. If there's something that you feel like has been redacted that I need to take a closer look to, or closer look at, then you can let me know. So we'll just do a normal reset. It's not likely we'll have them by then, but if you can, just because this has been going on a little bit, he's in custody, if you'll get with
Miss Adams.
Miss Adams. I didn't want to say, I was about to say her first name. I couldn't, but yeah, if you'll get with Miss Adams and see if they can kind of move this one to the top of the list for us, since he's in custody and we're waiting on it now.
And Your Honor, speaking with the state earlier about, just as far as trial dates go, August was mentioned. Is that about as far as?
So what'll happen is, we have to get to that point to where it gets placed on the trial docket. I don't just put anything on the trial docket to to kind of get more time. I want everybody to have all the discovery and then for it to for sure be a rejection of any plea agreement.
Okay.
And so what'll happen is once you are prepared to reject any offer, there's a document you'll do, a plea bargain rejection, so that I have something in writing.
Yes, sir.
As soon as that's done, it'll get placed on the trial docket. Our trial dockets are about 2.5 to 3 months
Okay.
turnover from the time that you get on it to
Gotcha.
the next
And
one.
I'll get a date with her.
But we'll need that rejection first and everything. And so I'm assuming you don't want to reject until you get the CPS records.
Yeah, and right now the current offer was from the last prosecutor. Ms. Pam here hasn't gotten a chance to fully review and give her own.
So I'll just do a normal reset and then Ms. French can get an offer to you and then we'll see where we get with regard to getting those records back. And as soon as that takes place, we can get it moved to the trial docket if that's what it's going to be.
Gotcha.
Okay.
Yes. Thank you.
Thank you. You can go back with the bailiff. See, it's Mr. Bruce. Good morning. Are you Justine Williams? And Mr. Rojas, will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Williams, in cause number 26, DCCR 0271, you're charged with the third-degree felony offense of obstruction or retaliation from December 8th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? That's good. Do you fully understand them? Do you understand those documents? And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? So you can't change your mind if I follow the agreement. Do you understand? Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Williams is not competent?
No, Your Honor.
All right, Ms. Williams, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of obstruction or retaliation. Sentence you in accordance with that agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could be lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. Good luck to you, ma'am. You can go back with the bailiff. Good morning. Are you Derek Corbin?
Yes, ma'am.
And I'm going to take judicial notice of the court's file in Mr. Corbin's case. It's 25 DCCR 1659. Mr. Corbin was evaluated for competency to stand trial, looks like at the end of January of this year, 2026, by Dr. Rapon. We received that report. The finding in that report is that Mr. Corbin is currently competent to stand trial. Understand that there's some issues, but that he is competent. Is there any other evidence with regard to competency?
Not to compass.
Not from state, Your Honor.
All right, then at this time, based on that report, I will find that Mr. Corbin is competent to stand trial. What is the announcement?
Judge, I received some additional medical some medical information in regards to Mr. Corbin from his family
Okay,
that directly relates to this case as far as with the allegations. So I do need to go over that with Mr. Nichols.
okay.
So I would ask some time so we can try to.
So I'll do one more, just a normal reset
Yes.
to make sure you get that taken care of. Mr. Corbin, we'll just do one more reset. Mr. Lewis will be out there to visit with
Yeah.
you once he talks to Mr. Nichols,
Yeah,
okay?
I'm constipated. I've been in jail. They don't want to send me to the hospital. I was sitting at this kitchen table that night and the voice is so.
Hang on. So let's not talk about the case. I'll make sure and send a note over to the jail to make sure that you're getting taken care of, okay?
Okay, I think I gotta go to the hospital.
Okay, you can go back with the bailiff.
The gavel falls on a man standing at the edge of the abyss. Larry Fitzgerald Williams does not speak, but his silence is deafening. He is charged with capital murder from June 2025. Yet 10 months later, the prosecution plays a deadly game of poker. They refuse to declare if they seek the death penalty. The judge, weary of the stall, issues an ultimatum. At the next reset, the state must answer, or the trial cannot move forward. The tension is procedural, but lethal. For the defense, this is not just a trial. It is a fight for a man's breath. Without the state's declaration, they cannot build a mitigation strategy or prepare for a sentencing phase that could end in lethal injection. The judge resets the case, demanding clarity. Then, the scene fractures. We meet Carlos Rodriguez, trapped by indecency charges and waiting on sealed CPS records, evidence that could free or damn him. The court handles motions for translation and in-camera inspections, the machinery of justice grinding slowly. But the emotional gut punch arrives with Justine Williams. Unlike Larry, she pleads guilty. Obstruction or retaliation. 2 years in Texas prison. She signs away her rights, her right to appeal, her future. The judge warns her about firearms, about deportation. She nods. Good luck, the judge says. As she is led away, we realize that while Larry fights the storm, Justine has already drowned.